How does immigration law differ between countries? If you have ever wondered why moving from one country to another can be so different, you are not alone. Immigration law varies widely around the world, and understanding these differences is key for anyone considering a career in immigration law. Each country has its own legal framework, policy goals, and historical context that shape how it handles immigration. For starters, let's look at how countries define immigrant categories. In the United States, immigrants are mainly classified under employment-based, family-based, and humanitarian visas. Each category has its own set of quotas and eligibility requirements. On the other hand, Canada employs a points-based system for economic immigrants. This system evaluates skills, education, and language proficiency to prioritize applicants for permanent residency. Meanwhile, Argentina takes a more open approach, granting civil rights to foreigners similar to those of citizens and categorizing immigrants as transitory, temporary, or permanent residents. Next, entry requirements can differ greatly. In the United States, visitors must have valid visas or qualify for visa waivers, emphasizing security and eligibility screening. Canada also requires valid visas or electronic travel authorization for eligible travelers, but the process is slightly different. Japan, however, has very restrictive immigration laws and a low acceptance rate for refugee status, making it hard for foreign workers to enter despite labor shortages. When it comes to policy objectives, immigration laws reflected national priorities. European Union countries face challenges managing open internal borders while controlling external ones. This leads to varied enforcement and political tensions among member states. The United States has seen fluctuating immigration policies influenced by political debates, with recent trends leaning toward stricter enforcement. Japan emphasizes cultural homogeneity and limits immigration, contrasting sharply with more open policies in countries like Argentina. Human rights and refugee policies also vary. Japan accepts very few refugees relative to the number of applications it receives. In contrast, European countries have experienced surges in asylum seekers, leading to intense policy debates. The United States and Canada both have humanitarian visa categories, but they differ in processing speed and eligibility criteria. For law students specializing in immigration law, these differences are essential to understand. They need to grasp comparative immigration systems to effectively advise clients. Skills in navigating diverse visa categories and eligibility requirements are vital. Students must also be aware of how political climates and international agreements shape immigration law and enforcement. In addition, analyzing constitutional protections and human rights frameworks is important, as these apply differently across jurisdictions. Immigration law is shaped by each country's unique legal structures and socio-political realities. Law school programs focusing on immigration law must equip students with the knowledge and skills to navigate these varied systems.